All right. Thank you, Professor Joe. For my topic is about the introduction of the Financial Consumer Protection Act, which was enacted this March. And so, can you slide next page? Okay. So I gotta briefly talk about the contents of Financial Consumer Protection Act, and then I will talk about the assessment for the enactment of the FCP.
So sorry, I'm not seeing any of Professor Koh's slides. I do apologize to interrupt.
How about other people?
I can see it.
I can see as well.
Okay, don't worry, I'll try and sort it out.
And I can see too.
Okay, next page. Can I control this slide?
I think you have to share to do so. So why don't I keep doing this?
Okay.
I'll try to be on time.
All right. Okay, next. Okay, so as I mentioned earlier, so this March, we have introduced a new act, which is called the Integrated Financial Consumer Protection Act. So in this context, I raise three main issues. The first one is that the Uniform Financial Protection Law will be effective way to protect financial consumers more strongly. That's the first question. And the second issue is that to what extent the regulation should be put into the law to more protect the financial consumers. For example, this act, we have introduced the new regulation for allowing the financial consumers terminate their contract in case where there is some violation of the regulation or rules, such as the suitability rule or expiration duty rule. So this is a very controversial issues in terms of reinforcing financial consumers. And third issue is that what kind of institutional structure should be implemented to protect financial consumers more strongly. For example, as Professor Andy Shimura mentions, the Twin Peaks system, which means that there is a separate financial regulators who is focusing of the business conduct of the financial service company, particularly the business conduct behavior. So now in Korea, there are very strong discussion about introducing such Twin Peaks system. So I'd like to talk about the three issues, or we may further discuss about these three issues. Okay, so this act has a long story because we have almost 10 years for enacting this new law. And because we have many cases of misselling. Okay, next page. Okay, I do. And 2008, we have very big event for the case of mis-selling, which is called the KICO derivative product, which is a currency option contract, in which case a lot of small business company had great damage from the derivative product, especially by banks. And also 2011, there was subordinate bonds mis-selling cases. And 2013, there are also the mis-selling cases, the Dongyang Securities Company. And recently, there is a mis-selling cases of the private hedge fund. So this is a very controversial and very big event. Okay. Let me introduce, talk about briefly overview of a Financial Consumer Protection Act. And this law focusing on the reinforcement of the conduct of business by financial company. And as I mentioned earlier, the second one is the allowing the financial consumers the termination right for the unlawful contract. And there is also the improvement of the financial conciliation or mediation system. Particularly, this law are focusing on the reduction of information asymmetry between financial service provider and the financial consumers. And finally is another supervision reinforcement, such as product intervention power, which are given to financial regulator. Okay, I'll go next page. This law categorizes three types of the financial product sellers, such as direct sellers, such as a financial company, banks or securities firms. And second one is the agent of brokers of financial product. And third one is advisors, particularly the independent financial advisors. Okay, next to one. Okay, we're gonna move on next page.
Okay, I think I have to.
Okay, here you go.
Sorry about that.
Okay, so there's also category of a financial product, such as a deposit type financial product, loan type product, investment type financial product, and insurance type financial product. And also this law reinforced the internal control system of financial company. Particularly, this law introduced 6 main principles for conduct of a business. Rules such as suitability principle, appropriate principle, and duty to explain principle of the prohibition of unfair business conduct, and principle of a prohibition of unfair recommendation or inducement of selling financial product, and also principle of regulation of unfair advertising. So this is the main 6 principles I think will greatly affect the reinforcement of the financial consumers, while these principles are very big burden to financial companies. And also this law particularly reinforce the remedies for damaged consumers. As I mentioned earlier, this law allows financial consumers terminate an unlawful contract, in which cases the financial service company violate the suitability rule, duty of explanation rules, such as that one. And also this law allows financial consumers the right for withdrawal of cancellation of offers. And this law also allows the consumers the demand for relevant materials, data from financial institutions. Another one of this law is to improvement in the system of the financial dispute conciliation or mediation system as the ADR, alternative dispute resolution. Now currently, a regulator, financial supervisory service, is conducting or operating financial dispute mediation committee. And this new law introduced a court order of suspension of litigation for the case in the process of financial dispute mediation. Secondly, prohibiting financial institutions bring a lawsuit to a court for the case of a disputed amount below 20 million won, which is a small amount in the process of financial dispute mediation. And also this law tried to reduce the information asymmetry problems in order to enhance the protect the financial consumers, such as improvement of a financial education system, such as establishing the Financial Education Council, consisting of officials from government department or experts, operated by the FSC, and also reinforcing the disclosure of financial product information. And one notable thing in terms of regulation reinforcement is introduction of the product intervention, which is a model of the United Kingdom's Financial Services and Market Act, which means that allowing the financial regulator to have a power to order prohibiting or restricting the sale of financial product highly likely to inflict damages to financial consumers. Further, this law introduced the punitive financial penalty, which is the administrative monetary penalty by the administration office, which is the FSC, Financial Services Commission. Okay, so those are the brief overview of the new law, Consumers Protection Act. And now I'm going to talk about the assessment of this law. My view about this law is that generally speaking, this is the new reformative skills for more protecting the weak financial consumers. However, I think there exists a possibility of increase of a financial dispute between the financial consumers and the financial services company in the matters of the cancellation of offer or termination of an unlawful contract. Also, the roles of the financial regulators, which is FSC and FSCC, become more important because for effective regulation, need for reshuffling the current the problem of the vertical dual system of the financial regulators, which is finally creating a more independent and specialized supervisor. That's my assessment of the FSC Act. And further, I would like to emphasize in this matter is for the reforming the financial dispute, the mediation system, which I think is very problematic in terms of the enhancing the financial dispute resolutions. As I mentioned earlier, is the regulators, the FSC is operating the financial dispute mediation system, which is unfair to the financial service providers because financial regulators are operating this one. And so in terms of maintaining the independence and fairness and impartiality of the mediation decisions, I think that the financial dispute conciliation institutions should be separated from the FSS, like United Kingdom's Financial Ombudsman Service and Australia's Financial Ombudsman Services. That's my argument for creating the new entity, which deal with the financial dispute conciliation schemes. Okay, the next one is that more infers the software scheme of the financial dispute resolution and allowing the financial FDCC decision to be binding on financial institutions once or if a financial consumer accept such decisions. The case with small disputes amount below 20 million won. This is a very controversial issue. I think that I strongly argue that this system should be needed to more protect financial consumers, which are weak parties. And United Kingdom recognize this binding effectiveness. And let's see, okay, there's another suggestion for requirement of a conciliation procedure before bringing a lawsuit. This is another one. And that's another issue for introduction of a class conciliation scheme, which is also very controversial issues. And next, let's see. Okay, okay. The finally is as I mentioned earlier, is a Twin Peaks regime as a financial regulator. This is very controversial issue. So recently, as I mentioned earlier, there's a lot of mis-selling cases of private active fraud, and now there's another very controversial issues for setting up the new financial regulator. In that, there is another issue for whether we, Korea, should introduce the Twin Peaks regime like UK and Australia. And even though I'm in favor of a Twin Peaks regime, but there's also a disagreement, in my opinion, saying that there will be some or many problems in Twin Peaks regime. Okay, so finally, let me conclude my talk. And I think that the enhancement of a financial consumers' right is the best way to the develop of the finance industry. That's the reason why the Korean government recently introduced a new unified financial consumer protection right. So that in terms of that, I also strongly argue that there must be a very strong and effective regulator, which we have many problems in the architecting of the financial regulator scheme. Okay, thank you for listening to my talk. Thank you again.